Folks that are here, identify themselves for me.
I'm Brian Dale, attorney for the union.
Yeah, Attorney Albert Termination for the city.
So, Mr. Mason, are you going to start with your case?
Yes,
Can I just ask you, is this a local hearing? You've heard this now
Yes.
before.
It absolutely is.
And what way of venue is on the prior decision?
None.
Okay, so you're not considering anything from the prior case?
Right, so my understanding is that this is de novo, we're starting all over again. Exhibits, testimony, start from scratch.
Okay, I'm going to move that you recuse yourself since you're a present matter of running a decision on certain possibility and bias. And the evidence is going to be any different, other than an update of what's happened since.
Well, if the evidence isn't going to be any different, did you folks discuss whether or not you would agree to waive any claims about the untimeliness of the prior decision?
We will not wait on timeless claims. As you know, the city failed to act in a timely manner on your recommended decision. And there's a civil service case pending, at least that's my understanding. We won't waive it. But you made a decision in this case, and I will hear it, you know what?
Well, so what authority do you have to suggest that I need to recuse myself at this point and can't hear it?
The case law to that effect, just the reality is we're going to make a decision in the case and expect the evidence to be the same, except for what's happened since.
Which may or may not impact the result. I mean, I don't know what's happened since.
I can summarize it in a minute. And that is, Mr. Atwood has run out of any kind of accrued leave that he has. He's on an unpaid status, kind of like being retired. And in the interim, at the time of the last hearing, he had bid on the position in dispatch. Since then, he was awarded that position of regular bidding, but the city has refused to let him work in dispatch.
What's your position on Mr. Rogal's request that I recuse myself?
well, in regards to this hearing, chapter 31, section 41 hearing, you are a recommending officer. The final determination comes from the mayor. The last time we were here and a recommendation was written, as you can recall, one of the things that you clearly pointed out was there are issues here that you couldn't recall, such as reasonable accommodation. And as a matter of fact, you pointed out whether or not reasonable accommodation can be made to allow Atwood to continue to be employed is not a matter for this hearing officer, which it isn't. And the hearing officer encourages the parties to explore such options. That basically is what happened from the day that you walked out of this room, and the day that the parties walked out of this room. From that day forward, to the best of my knowledge, the chief and the union have been exploring the reasonable accommodation issue. The reasonable accommodation issue involves a situation with dispatching and whether or not Mr. Atwood would be willing to perform as a civilian in the dispatcher, which would, in the city's opinion, continue his group insurance, continue his employment with the city.
Well, let me stop you. That doesn't go to the issue of whether or not I should recuse myself. I mean, that may be additional information, or it may go to the...
Well, as far as recusing yourself, what I'm saying is, I wouldn't think that there's any necessary reason for you to recuse yourself from the point of view that what you heard is the only thing is you can hear it again in addition to the reasonable accommodation that was not resolved back when you heard what you heard. I have no problem with letting what you heard stay and then just addressing the reasonable accommodation if you want, because we've entered all of that evidence, the union has entered it, and, you know, because that's all that transpired since that hearing was the reasonable accommodation issue. So, as far as recouping, I don't think there's any need to recouping, either, reissue the same recommendation without the reasonable accommodation issue, or as a matter of fact, just hear the reasonable accommodation issue and issue a decision saying that my understanding the parties have addressed it and are unable to resolve it. That's where I think we are.
What do you say to that?
I think you can consider reasonable accommodation as part of your decision. I don't think you necessarily get a rule on an 151B claim, there's a service claim, but I think you can factor it in. Just so you understand. Their idea of reasonable accommodation, let me step back a second, you may know, that in Lawrence, you have a dispatch center, I'm center, you have civilians working in that center, you have firefighters working in that center. Chief's idea of reasonable accommodation is that Mr. Atwood should resign as a firefighter and apply for a position as a civilian. He then would come in and if he got that, he would work in the same job, in the same site, an acknowledgement that he can do all of the duties in that site, he just wouldn't be a firefighter. That's not a reasonable accommodation to his job as a firefighter. So the only thing that's changed is he's bid in, he has a right to be there, and this is you're going to get. I want to move this along, my motion appears, whenever you recuse yourself, then I would say, we do not require repetition of the evidence at the prior hearing.
Okay.
I don't think that's going to serve any purpose. You've heard it. Motion to recuse yourself because you've already made a decision based on that evidence. And there's very little additional evidence. I expect the chief to stand on his position that termination is, he wants termination because theoretically Mr. Atwood could be called out of the work in the dispatch center and would not be able to necessarily do everything that a firefighter could do in an emergency situation. And our position is that never happens. He can do everything in the dispatch center, and I don't expect any evidence to the contrary.
I understand that, so what I'm trying to do is find a way that we could move this process along. Because it has been
So
to everyone's benefit.
And the union really, from the union's point of view, is they spend money for me to be here on second hearing solely because the city failed to act on the recommended decision one way or the other in a timely fashion. And that's why there's a new hearing today. So it just costs everybody time and money. Leaves Mr. Atwood in limbo. And when they refuse to pay him during that time. So I suggest you make a ruling. If you decide not to recuse yourself, we will agree that the prior evidence can be considered in this case and should not be repeated and start from there.
Yeah, I do not think that there's a basis to recuse myself because I think I can hear any evidence that there might be that is additional to what I heard before without any predisposition one way or the other. That said, I'm fine with acting on the prior evidence and allowing each of you to provide any additional evidence because I do think that Firefighter Atwood has the right to a de novo hearing and to add any additional evidence that was not brought forward the last time. So I'm going to give you leeway on that. Whether it's something that could have been raised by either side before at the other hearing, or whether it's additional evidence regarding what has occurred since. In terms of the settlement negotiations between the parties and the accommodation alternatives that have been proposed, I'm not sure that's something that I need to know about, but if either of you think that that's relevant to the decision in this case, I'm happy to hear why you think so. And we can move forward with that, but my expectation at this point is that Mr. Mason goes forward with his case. And if you're saying that he doesn't need to have the same testimony, you agree that he doesn't need to present the same testimony over again, then I'm fine with that. I have my notes. I have a pretty good recollection of what occurred. And if there's anything additional to present, I'm happy to hear that.
That was my position.
And again, that's fine and acceptable to the city. In other words, it's our position as Attorney Logan, what was entered has been entered and can be resolution. And as you indicated, reasonable accommodation is not for this forum. As a matter of fact, it's my understanding from the chief that reasonable accommodation is already being addressed either through the MCAD or the EEOC. There has been a charge on that, and it's going to be assessed there. So that in this regard, I would say that all we would be seeking is that you, if you will, reissue your recommendation without any reference to the reasonable accommodation, because that's being addressed elsewhere. Then the mayor will have to write his decision, and then we will have to go from there with civil service and the EEOC or the MCAD, whichever chooses to be.
Well, that, you may have to go forward on another case, but the obligation 151B is an obligation for this city and every employer to comply with the law regarding handicap discrimination, and you can't ignore it, nor can the city, unless it wants to violate that law.
So, do you intend to present any additional evidence at this
No.
point? Okay.
No.
Now, how about you?
I do.
Okay.
Chief, since we're here last, you said Firefighter Atwood bid on the position in dispatch, correct?
That's correct.
Is that the proper term for dispatch or fire alarm? What's the proper term?
Dispatch or fire alarm operator, either one.
All right. And he was a successful bidder,
That's correct.
so that under other circumstances, someone else bid on a successful bidder, they would then be working in that location. Is that fair to say?
Assuming that they're in a healthy position where they can be working as a firefighter, yes.
Okay. Mr. Driscoll bid on that position, and he was a successful bidder. Would he then be in that position?
He is active duty firefighter, yes.
Okay. You refused to let Mr. Atwood work in dispatch, is that correct?
That is correct.
All right. And last time, fair to say that last time we agreed that Mr. Atwood could do all of the duties that are normally required in fire dispatch.
That is correct.
Do you have any evidence to the contrary now? And in fact, the accommodation that was offered was to have him resign as a firefighter and apply for a position as a civilian dispatcher. Is that correct?
That is correct.
Right. So you didn't offer any kind of accommodation that would allow him to stay working as a professional firefighter, did you?
The evidence that I have from his trade position indicates that he has a permanent
But
disability.
what's helpful if you would
He no
answer,
longer perform the duties of a firefighter.
what you need to do is answer the question I asked you. If you would like to, the council can ask you other questions if you feel it's appropriate, he feels it's appropriate. The question I asked, if I'm on track at this point, is, there's no, you have no basis now to show that he can't do all the duties in the dispatch position, correct?
He could perform the duties as a dispatcher, yes.
And no other accommodation was offered to him that would allow him to remain a firefighter, is that correct?
That is correct.
Also correct that he's run out of all of his paid benefits, he's on an unpaid status now?
He still receives health care benefits.
Okay. Does he receive any pay?
No, he does not.
Does he have any accrued vacation pay left?
No, he does
Does
not.
he have any accrued sick leave left?
No, he does not.
And he has been denied injured on duty pay by the city, is that correct?
There is no basis for injured on line of duties.
So it's correct to say he has been denied.
Uh,
He applied, he asked for it and was not
He's
received, right?
been denied. Under the law, the evidence indicate that he would have been denied duty injury. I do not have that.
So, sir, so your position is that he should be terminated, correct?
I don't believe I have any other options.
And sole basis is because in some kind of emergency, he might be called on to do, sent out to work on a fire, do something he couldn't physically do.
It is a distinct possibility, yes.
Between the last hearing and this hearing, has it ever occurred that a firefighter assigned to dispatch has been called out in an emergency?
Not to my knowledge.
If Mr. Atwood is terminated, will he be replaced as a firefighter?
Yes, you will.
And have you calculated the cost to the city of replacing him?
There's certainly a cost, but I believe that's irrelevant at this point.
It's not, it's irrelevant to the city how much to replace someone who can work as a firefighter in a position that you have?
You cannot work as a firefighter.
He can work in dispatch, right?
Yes, you can.
Okay. And the cost to the city of having to train and pay someone to train and get that experience and equip them, that's irrelevant?
The city pays Atwood as a firefighter. As a firefighter, he's expected to be able to perform all full firefighting duties. He has a permanent disability where he cannot perform those duties.
How many firefighters are assigned to dispatch?
4.
Some of them are less senior than firefighter Atwood?
Yes.
And fair to say that at least some of those less senior firefighters would prefer a different location?
No doubt.
Just have one. Nothing further for you?
Do you have any questions for the chief?
Chief, as far as firefighter Atwood, is this termination hearing, well, we know why this termination hearing was called. And can I ask you, what was the reasonable accommodation that you offered to firefighter Atwood?
Because firefighter Atwood is no longer to perform the full duties of a firefighter, the city offered him an accommodation to resign his position as a firefighter. We would employ him as a civilian, as a dispatcher. He would never be called upon again to perform the full duties of a firefighter.
And there are other firefighters that are performing dispatching duties, is that correct?
That is correct.
And what they are all subject to and able to meet the call as a firefighter if needed.
Yes, they are.
And firefighter Atwood, by the medical documentation that you have, although he may be subject to call as a firefighter, is not able to perform as a firefighter, is that correct?
That is correct.
I have no further questions.
I have a couple of questions. Chief, what's the difference between a civilian dispatch, somebody having a role in civilian, as a civilian dispatcher, and somebody being a firefighter as a dispatcher? What would be the difference
There
to?
are 2 main differences. One is that they, first of all, no longer a civil service employee,
Right.
enjoy the benefits of civil service protection. But the second is there is a 25% pay difference between a firefighter and a civilian dispatcher. The benefits are the same as far as the overall benefits. They are covered by the firefighter's contract with the city and enjoy all the benefits. The only difference is the pay difference.
Okay, and it's a 25% pay difference.
That's
The
correct.
duties are the same, but the pay is different.
Well, again, as a dispatcher, yes, the duties are the same.
Okay. Yeah, he wouldn't be called out to
Correct.
perform active duty.
Yes.
And is it correct that the reason that you've concluded that firefighter Atwood shouldn't be a firefighter dispatcher as opposed to a civilian dispatcher is his inability to perform all of the duties of a firefighter?
Correct.
It's confined to that alone.
Yes.
As opposed to-
That one position as just one dispatcher. Whereas the other firefighters who are assigned there could be called out to perform the duties of a firefighter.
I don't have any further questions of the chief. Does anybody else have any other questions?
I don't think
Do you have any other testimony you'd like to offer?
I just also have 1 more minute. just ask the chief a question.
Sure.
Just to reconfirm, I asked you a question, since last hearing, you don't have any knowledge of anyone being called out of dispatch, any firefighter being called out of dispatch to do other firefighting duties. Do you know of any, have you uncovered since last hearing, any incident in the history of the department where a firefighter has been called out of dispatch to perform other duties?
Off the top of my head, no. However, if I might add, right now I have 38 firefighters that are funded under a federal safer grant. There is no expectation that that grant is going to continue. At some point, those funds are going to run out. Whether or not the city is going to have the ability financially to fund those positions when that money runs out, I don't know. But what I'm looking at in the very near future is a possibility that we might once again have reduction of force here in the city of Lawrence. And I will need every able-bodied firefighter, including those who work at dispatch, in order to perform firefighting duties. Whether it's being called out to assist as a pilot, in which case they'd be, riding another piece of apparatus to a scene where I expect them to do a full firefighting, would be exposed to things like smoke, which would, someone would, for instance, Atwood's condition with his asthma would be detrimental to his health.
So, the answer to the question I asked is, you recall I raised this in the last hearing about whether any firefighter had ever been called out.
Actually, now that I think about it, firefighters who are assigned to fire alarm dispatch are on our overtime call list, and they do work overtime on the trucks on a regular basis.
Okay. And that's, they can work overtime, they're not required to work overtime. Is that fair?
Well, they might be charged with the refusal if they don't.
Okay. And what happens if
And that could end up, being a matter of subject of agreements.
but they can refuse to work overtime?
Yeah, can't force anybody to work.
So come back to it. Last time I made this point, I asked you to be aware of any time when a firefighter assigned to dispatch had been called out, an emergency. We had this colloquy about it could happen.
Yeah.
Since then, and knowing you had another hearing coming today, and probably understanding that I might go back to this issue, have you uncovered any incident in the history of this fire department where to date a firefighter has been called out of dispatch?
Off the top of my head, no. And again, I did not research that. However, again, what I perceive is that I'm facing a possible reduction in force, and I'm going to need every able-bodied firefighter, including those who are assigned to dispatch.
So your
Times are changing.
your budget is tight, is that what you're saying?
Times are changing.
Budget is tight, sir? You worried
Right
about your
now-
budget?
Right now, we have 38
And
firefighters
where's the budget?
under federal
Sir.
funds.
The point, the way this works, I asked a question, you and I were just answering the question. Are you worried about your budget?
Madam Chairman, I would respectfully object to this line of questioning, and anything going on continuing to a reasonable accommodation issue. That is an issue that is in litigation in a separate forum, a forum that is designed and jurisdictionally required to address and rule on that issue. And any and all of this testimony can be taken there, will be taken there,
Not in the middle of the hearing.
can be ruled on there as opposed to here.
First, I'm not sure that any of the budget considerations are relevant to the decision that I need to make. With respect to the reasonable accommodation issue, is there any authority that you have that to say that I have the ability or the jurisdiction to address that issue here? To decide whether or not it's reasonable for the city to say that they need him to be available to be called up?
I don't have case law off the top of my head, as has been suggested. I'm very familiar with 151B, and suggest that, since it's a law of the Commonwealth, of course backed by Title VII laws that apply, that it has to be consideration, that although, because of the collective bargaining agreement, there has to be just cause for discharge. This is a civil service hearing, which essentially is a just cause standard as well, that the city cannot fire someone for an illegal reason or in violation of the statute. And I suggest that you have the authority to look at that, understanding, of course, your decision is a recommended decision as well. But certainly, the appointing authority will have to consider that factor, making a decision as to whether to discharge. And it's been laid out in unequivocal terms here by the chief, what his view is, and appreciate that. He stated his view plainly here, but it's going to have to be addressed, because the law clearly says that accommodations have to be made. And under the law of handicap discrimination, those accommodations include changes to the job. They include eliminations of non-essential functions of a position. You're right at the heart of it.
No, I understand. I mean, the issue is teed up perfectly. It's whether or not there's been a reasonable accommodation, or whether it would propose an undue hardship on the city in order to accommodate Firefighter Atwood as he's requested. And what I'm trying to figure out, what authority do I have to rule on that, especially if you've got a charge of discrimination pending at MCAT?
I don't have a charge of discrimination. I don't know if there is a
There's
charge of
somebody else.
discrimination pending.
Somebody representing firefighter.
I'm telling you that there's a viable cause of action if the city goes down this route. Whether or not Mr. Atwood will choose to go that route or not, I don't know. And I don't know whether he's got it this time. I think that there's an obligation to take into consideration that it violates the law. As you say, undue hardship on the city. I haven't heard any evidence of undue hardship. I do have a further question for the chief on past this.
Well, I mean, that's the issue, and I don't think anybody's going to disagree with me that the issue is whether or not the city is able to accommodate him. And whether or not the request that he's made is reasonable, or whether the city has offered a reasonable alternative by saying they'll hire him as a civilian dispatcher. What I'm struggling with is, under the statute, it's pretty specific what I'm able to do, and I don't see how I'm able to make a determination. I mean, I don't think I have enough evidence at this point, but should I even be diving into evidence of whether or not a reasonable accommodation exists or whether it's been made? What's my authority to do that?
Well, I think that's basically under the statute, because it would violate the law to fire him if there was not a reasonable accommodation made. And we have given you evidence that he can work in a dispatch center. And in a sense, transferring him there is not even a reasonable accommodation anymore, since he bid in and he would have a right to it under the contract. He has a right to that position. So he's saying he can't do that position, not because he can't do the work in that position, but because theoretically, in an event yet to occur, he could be called out of there. That's what the city's saying here.
No, I understand. The city's not saying that he can't perform all of the required duties of a dispatcher. The one thing that he can't do is be called up to actively fight a fire beyond a truck.
I think you have all the evidence you need from our side here to establish that there's a position that you can do, and that it's not essential that the firefighters are assigned to that position, that would like not to be assigned to that position. It's a job that's routinely done. And one further question I would ask, if there's any dispute on this, is the contract requires that you keep 4 firefighters assigned to those positions. Isn't that correct, Chief?
The side agreement on the contract.
I'm
It's
sorry?
an undated side agreement on the contract.
So there's not a side agreement on a collective bargaining agreement that you
Madam
have
Hearing Officer, this is reasonable accommodation. You have already written that whether or not there are reasonable accommodations with being made is not a matter for here. It is not. It is a matter for EEOC, MCAD, it is there. This is prolonging a determination that should be made relative to the facts that are here other than that issue.
I understand that that was my decision, and that was based on my understanding of the law and what my role is here. What I want to know is if the attorney has any basis to suggest to me that I was incorrect, and that I do have jurisdiction to hear what basically amounts to a 151 action.
Oh, I don't think so. I don't have case law for it, to be correct. At least not yet. Two, don't look at it as reasonable accommodation. Just cause to terminate him. He's a firefighter. He's got a right to this particular position. The position exists. There's a contractual obligation. Chief says it's in a side letter, but it's always been adhered to do the position. He can do his duties. Where's the just cause to terminate him if he can do that duty? I'm not asking for reasonable accommodation. You know, I mean, it can be viewed that way as well. There's simply no just cause to terminate him from the position he's been assigned to. And last time we were here, he had not yet successfully bid into that position.
Right.
They were asking for him to be moved to there because he could do the position, but since then, he has a right to that position. That hasn't been challenged. You don't even have to go to reasonable accommodation to find the just cause.
Let me follow up with a couple of questions. How, he was the successful bidder for the dispatch position, is that accurate?
One of the 4 positions at dispatch, yes.
Okay, and what criteria is used to determine that? How does he become the successful bidder?
Seniority is a part.
Okay, he
As a
asked for the
firefighter.
position and
Yes, he was the most senior member
who asked
of
for it?
the position.
And so there's no determination that's made as to qualifications or anything like that. It's bidding in and it's based on seniority.
It's a firefighter's position.
And once he was the successful bidder, what do you do as the chief? What's the process you go through to determine whether or not he's going to be able to perform that job?
First of all, again, he's a firefighter,
Right.
so he has to perform all the duties of a firefighter, which he's not able to do. Could he perform the duties at dispatch? Yes, he can. However, I cannot return him to work as a firefighter because he's not able to do the work as a firefighter. He's subject to recall, even as a firefighter working at the dispatch center.
And am I correct that there's no, and anybody can answer this, that there's no separate job description position for a dispatcher? It's a firefighter.
I'd have to ask, let me this might help you.
Yeah.
Firefighter Atwood has previously worked in that position and has done all the duties in that position.
I don't think anybody's disputing that he can do the duties of that position. Am I right? Nobody's disputing that he could effective dispatch. The issue is that he can't perform the other duties that are required of a firefighter under the job description that's in the statute. Is that right?
That's correct. He can't perform the duties of a firefighter. He bid as a firefighter.
So the issue is not can he do the dispatch duties, the issue is that he can't do the other
Is he
duties.
subject to call as a firefighter? And I would submit for the record that this is not the first time a reasonable accommodation and/or a 111F injured on duty issue has come before the Civil Service Commission as a whole, and I have been there with them, and they have declined to exercise or make any rulings on either injured on duty issues or reasonable accommodation issues, because that is not their form. And I submit that's not this form.
Anything else?
Nothing further, thank you.
Anything else from you? Okay, thank you.
Thank you.